Okay, good afternoon, everyone. So, thanks again for joining us. We are still on the revised rules of civil procedure and evidence. This time, this is part two of the revised rules on civil procedure. So, I hope everyone had a good week last week, and I hope everyone is keeping safe and staying healthy and staying away from the crowded places. It's crazy out there. So, just a few reminders before we proceed with the session today. Um, the Q&A, the questions will be entertained at the end of Justice Singh's presentation later on. So we will cover as much as we can all the questions that were sent or that were posted from last week's session. And then if you have new ones, you may post your questions in the Q&A box found below your screen. Or if you're using an iPad, I think it's on the top part of your screens. And then the link to the PowerPoint presentation will also be posted in the Facebook page of the UST Faculty of Civil Law. And also the video for those who would be missing certain parts of today's session, you may catch the video also posted in the Facebook page of the UST Faculty of Civil Law. Okay, so without much ado, let me turn you over to Justice Singh for the continuation of her presentation. Justice, good afternoon.
I'm sorry, my microphone was muted, so I'll just repeat it. Thank you, Attorney Renz. Thank you, Dean Nilo. And thank you to all of you for joining us today for the second half of our session on the revised rules of civil procedure. So we start today with Rule 19, that's interventions. And there are actually no substantial changes in Rule 19. And what I have for you, if you go to the next slide, Attorney Renz, are just quotes from decisions of the Supreme Court regarding the concept of intervention. Of course, the mandatory requisite there is that the intervenor must have an actual and existing legal right. And if the rights of said proposed intervener can be fully protected in a separate proceeding, and if the intervention would only result in delay to the resolution of the rights between the original parties, then the intervention may be or will not be allowed. Let's go to the next slide. Also still on the nature of an intervention, as ancillary, it's not independent. Okay, let's go to the next. Rule 21 is the rule on subpoena. Okay, we skip Rule 20, which is the rule on calendar of cases. It is untouched. It remains the same, no? But just as a reminder, it directs all courts to keep their calendar of cases to be under the control of the clerks of court and of course under the supervision of the presiding judges, right? But under Section 2 also, we are reminded that the assignment of cases is done only by raffle, no? In our e-courts, and now because of the ECQ and the MCQ, even GCQ, the raffle of cases by electronic means through video conferencing is also highly encouraged. Okay, so let's go to Rule 21 on subpoena. There is a change, actually stylistic only, in Section 6 on the service of subpoena. It refers to the payment, no, or to the charging of the cost for the court attendance of witnesses and the production of materials that are required for the testimony. Before, we called it kilometrage, no? Of course, the schedule of fees are in Rule 141. You find them there. But here, the court thought it better to word it this way so that it will be clearer. Okay, next. Let's go to Rule 23. We go now to the modes of discovery. There is really no substantial change in any of the provisions on rules of discovery, except that modes of discovery, I should say, except that here in depositions under Section 1, the court thought of removing the former distinction. Before, there has to be leave of court, no, before jurisdiction over the before there is an answer, no. But now the court use the uniform language of only upon ex parte motion of a party. So wala nang distinction yung by leave of court or after an answer has been served, no more leave is required. So ngayon lagi upon ex parte motion of a party, right? So the same revision applied to Rule 25 on interrogatories to parties, and you will see in Section 1 of interrogatories, we make the same or we employ the same language, no, upon ex parte motion of a party. So we also remove the distinction. Okay. Now let's go to Rule 30, which is trial. This is the more important the more important revisions, because here you are all aware that we have already continuous trial in criminal cases, no, where the timelines have been compressed, and the dispositions of criminal cases have really been sped up, no, in this as a result of which the appeals also have piled up in the Court of Appeals, no. But not complaining because the people are happy their cases are being decided at a faster pace, no. And you have appeals also for review, no, just to ensure also that it's not just quantity but quality also that we have, no, in the judiciary. All right, so now what is the schedule of trial, no? And I have reduced this. We will not read it. You read it at your own pace, no? But I will just explain to you simply, no, what are the steps, no, for our trial in civil cases from now on, no? So you will have the filing of the last pleading, no? The filing of the last pleading, well, it could either be an answer or a reply, no? Or when an actionable document is attached to the answer, or if an actionable document is also attached to the reply, then you can have a rejoinder. That will be your last pleading. Okay. So whatever the last pleading is, you count 5 days from that, and the branch clerk is directed to issue a notice of pretrial. Right? We discussed that under the rule on pretrial last time. So from the issuance of the notice of the pretrial, you have to count 60 days, or you have to set the pretrial within 60 days. Okay. So if the last pleading is filed today, the branch clerk, of course, upon the directive of the judge, must issue a notice of pretrial within 5 days from the date of the last pleading or the expiration of the period to file the last pleading. And then that pretrial must be set within a period of 60 days from the date that the last pleading was filed. Okay, so there you have a timeline already. Mabilis, no? So, pero you may say, bakit 60 days yung from the date of the last pleading? You have to give allowance, no? You have to give allowance for the parties to prepare for pre-trial. Kaya 60 days yung aming napagkasunduan na period doon. Okay, now from pre-trial, after the pre-trial is completed, the court will count 30 days, no? And then within that 30 days from the date that the pre-trial is completed, the court must set the initial presentation of evidence for the plaintiff. Okay, so very very rigid yung natin, yung schedule natin, no. So 30 days initial presentation of plaintiff's evidence. Now, how long does the plaintiff have to present his evidence, no? The plaintiff has 3 months or 90 days max, no? Maximum na yun. To present all his or her evidence. Okay, so under the revised rules on trial, so remember again, 3 months or 90 days. Yung 90 days natin, calendar days, remember? Okay, so yun na yung maximum natin. Plus, there's a colatilia here that 90-day period will include the period for JDR already. Ha? So judges, yung ating 15-day period na inaalaw natin ng JDR, where we refer the case to another judge or another court, ma-minus natin sa 90-day period na yun for presentation of evidence for the plaintiff. Ibig sabihin, mas lalong mako-compress yung plaintiff, okay? Bakit 90 days? Why did we agree on 90 calendar days or 3 months max? As I told you last time, no, there were 3 judges on the, well, ako ex-judge, no? So, tatlo kaming judges doon, trial judges doon, meron kaming 2 practitioners, no? And then, of course, we had Justice Lampas Peralta and retired Justice De Leon, no, from the CA. and Justice Esmundo, and of course the Chief Justice as our working chair, we all agreed that 90 days is enough, no? Sa experience namin, sa collective experience namin lahat. Kasi yung mga civil cases naman natin, hindi parang criminal cases sa dami ng ipepresenta natin na ano na mga witnesses, no? So if you have a civil case where you have 5 witnesses or more, ang dami na talaga noon, no? That would be a really complex case. But in our experiences nga, hindi naman ganon. So we determined that 90 days, more or less, is the average, okay? So after the presentation of plaintiff's evidence, meaning after the lapse of more or less 3 months, no? Lalabas naman yung offer of evidence ng plaintiff, which should happen in 1 day only. Actually, sa rules natin, dapat yan on the day that you complete the evidence presentation, you orally offer your evidence. Yan na yung rule natin sa continuous trial, di ba? Sa criminal cases. So, on the day that you present your last witness, you complete your evidence. That is it, no? You complete your evidence presentation. You are supposed to orally offer your evidence. And then when we discussed the rules on evidence, no, I think last week, we already said that the offer is not, it's not only the offer that has to be orally, but also the objections, no? So how do you do this? Do you listen to the oral offer first and then you give the other party an opportunity to object orally also? What I advise is that you have the offering party do his offer per exhibit. Okay, so exhibit A, offer, purpose. Okay, and then you listen to the objection agad, and then you make a ruling. Yun para sa akin ang mas easy, tsaka mas maliwanag, hindi confusing. Kasi if I'm the counsel for the plaintiff and I have, let's say, just 10 exhibits to offer, okay, and then the judge will listen to my offer for all 10 exhibits and then listen to the objections after. Hindi na fresh sa my judge. Ano ba yung ino-objecta na exhibit nga ulit, 'di ba? So the judge will have to refer to his or her notes, no? So for everyone's facility, I think it is better, no? If there is an offer per exhibit, an objection per exhibit, and then the judge can also make a ruling by exhibit all after the offer and the objection para orderly tayo, no, in our procedure, right? Okay, so then 30 days from the judges or the court's ruling on the offer of evidence of the plaintiff, the judge must set the defendant's evidence presentation. Okay, so ganun din is given 30 or 3 months or a maximum of 9 days, calendar days po, to present all his or her evidence. Okay? Siyempre, kung dumadami yung parties natin, halimbawa, 2 defendant mo, okay? So, bigyan mo siya ng equal chance, no? Hindi ibig sabihin no na hati yung 2 defendant do sa 90 days. So, ibig sabihin hahaba yung presentation natin kasi 2 silang defendant or 2 silang plaintiff if they will not be presenting common or unified evidence, all right? Okay, so after the defendant's evidence presentation, there will be an oral offer also, no? And in the same manner, there will be oral objections and then a ruling in the court, no? After that, what happens? It depends, no? Meron ba tayong third-party complaint? Meron ba tayong permissive counterclaim? Meron ba tayong cross-claim? Because if we have any of those, then we must set the presentation of evidence on those claims also, no? And under the revised rules, we also gave the third-party complainant or the cross-claimant or the counterclaimant, no? Under a permissive counterclaim, we gave them 90 days also. Pantay-pantay, no? Kasi kanya-kanyang claim, they must have an equal opportunity, no? Yung sinasabi nating the proverbial day in court. All right, so we're giving them also 3 months or 90 calendar days to present their evidence, no? So after all that is done, no? So naka 3 months na tayo for the plaintiff, 3 months tayo for the defendant, naka 3 months din tayo for the third party complainant. Let's say there's one, no? So, paano ba? Is that the end already, di ba? So, syempre, may offer din sila. After that, after na-admit na ng court yung evidence, do we submit the case for judgment? Pwede na. Unless either the original plaintiff or the original defendant request that they be allowed to present rebuttal evidence, no? In which case, bibigyan sila ng chance. Pero 30 days maximum for both of them na yon, no? So hati sila dun sa 30 days. Kung gusto nila to present rebuttal evidence and if the court deems it justified, no? Kasi may dapat bigyan ng chance to rebut what the evidence presented, no? bibigyan lang sila ng 30 days maximum for both the original plaintiff and the original defendant. Ito total mo yun lahat, the maximum that we will have is 300 days. Tagal din, no? Or 10 months, no? For lahat na yun, kung may kasama ng counterclaimant or cross-claimant or third-party complaint, no? And then kung may kasama na ring rebuttal evidence, yun ang maximum natin, 10 months or 300 days. But if simple case, plaintiff, one defendant, no rebuttal evidence, in a matter of 6 months, half a year, no? Tapos na tayo. And hopefully, this will be the abs, no? So that's the summary of our provisions, our revised provisions on the schedule of trial, okay? And then if you go to paragraph C, you will see the period to decide is still the same, no? It's still 90 days. Pero dito, the important provision maybe that I should highlight is that there is no requirement for the filing of memoranda, no? Although dati din hindi naman yan mandatory, yung judges naman were given the discretion, no? To require the filing or submission of memoranda from the parties. All right? Let's go to the next slide. So adjournments and postponements, no? So bawal na ang rule na natin na prohibited pleading na or prohibited motion na yung motion for postponement, no? Except in instances, and we repeat them again, acts odd, force majeure, and then the third one is physical inability to go to court. So dun papasok yung medical excuse natin, dun yung mga illnesses, doon papasok sa physical inability. All right? Okay. And then of course the rule now is that whoever causes the postponement must bear the loss in time. Ibig sabihin, kasi doon pa lang sa pre-trial, may schedule of trial na tayo may flow chart na tayo doon. So if the plaintiff, for example, asks for a postponement for whatever reason, no, allowed under the revisions, then the plaintiff will suffer the loss in time. Meaning, kung binigyan siya ng 5 days to present evidence, mawawala yung 1 day niya. Hindi siya bibigyan ng additional day. What the plaintiff needs to do is to complete the presentation of his or her evidence during the remaining days apportioned to him by the court. Okay? All right, let's go to section 4, hearing days and calendar call. It's still the same, no? Our hearings are scheduled from Monday to Thursday and from 8:30 a.m. and 2 p.m. Of course, because of the ECQ and the GCQ, ano pa ba yun? MCQ also, medyo nagkaroon ng kaibahan sa mga time natin, no? But with the video conferencing, okay, nagkaroon mas leeway then to still comply with the time requirements under the rules. Bakit walang Friday? Because Friday we have already set aside as motion day, right? Okay, go to the next slide. Okay, the succeeding slides just show you yung administrative circulars natin for ECQ, yung Enhanced Community Quarantine. And I will not discuss it alone kasi nag-issue na rin ng Chief Justice natin on May 14, 2020 of the guidelines for modified community quarantine. We also have the guidelines for the general community quarantine. It's all here, no? You can look at it and I'm sure you're aware of it also. If you are working for the courts, lahat kami alam na namin yan. Pero for the litigants, I have it here. You can refer to it at your leisure also, depending on where you are, no? Pero I just want to stress because the MCQ guidelines are not here yet, no? Kasi they're of recent issuance lang. The same naman ang provisions. Okay, I'll discuss the provisions one by one. The first one is our courts shall remain physically closed, meaning wag kayo pumunta sa courts, okay, unless pinatawag kayo ng court, okay? But that does not mean that we are not work, okay? Work from home po yung marami sa amin, pero meron din po kaming skeleton workforce na nandoon, nagtatrabaho. Pero hindi nyo sila kailangan makaharap face-to-face. For example, you want to follow up something or you want to get a document, you cannot go there and get it personally or follow up personally. Ang nakalagay po sa guidelines natin is that you contact the court's official contact phone numbers, and then you can also, we have hotlines, no? And you can also do it via email. Meron na pong judiciary account emails ang ating mga trial courts. And then you can also do it through, I don't know for Facebook accounts, I don't know if that's official, but with the approval of the Supreme Court, okay? Pero kung meron po tayong electronic communications, may nagka-cut off po tayo ng 2 p.m., no? Just to give time for the court to actually receive it. Kasi minsan, due to problems of connectivity, di ba? Hindi po agad-agad natatanggap. Tapos, if there is some action that needs to be taken, give us a little elbow room, okay? All right. And then regarding raffle, no, there is raffle. Raffle of cases continues, no, pero electronic po. Through the video conferencing platforms that have been assigned to us by the Supreme Court. So I, for one, in the Court of Appeals, we already did a dry run of our video conferencing capacity the other day, yung division po namin. And today, I know that we had raffle in the CA earlier this afternoon, no? So it's continuing, no? And then, can you still file new cases? Yes, you can still file new cases. Pero ang filing po natin ngayon, limited lang po sa electronic submissions, no? And or if may mga urgent matters po like motions, like for those affecting persons deprived of liberty, then inaalaw po yata ang paper submissions. Well, not yata. Allow po ang paper submissions, but we, of course, observing the necessary health precautions for everyone, no? And then, what about yung mga due dates ninyo, no? So, in both the ECQ and the MCQ guidelines issued by the Supreme, binibigyan po tayo ng extension. If your due dates fall within the period that we are still covered by the ECQ or by the MCQ, then you are given a 30-day extension, no? So you will see it in these provisions, okay? And then under the MCQ, dun sa modified quarantine rules, pinapaga na rin po yung civil wedding rights, no? Pero may limitation po of up to 5 persons in attendance only, no? A lot of my friends have asked me, can we do it via video conferencing? Sabi ko sa kanila, although that would be ideal for everyone's safety, pero meron pong substantive requirement ang family code natin regarding the marriage right. And hindi po pwede, in my view, to do it via video conferencing merely through an administrative issues or a rule, no? Kasi substantive provision of law po yung family code. So baka hindi natin pwedeng gawin yun kasi hindi po tayo ang nagpasa nun, no? That's a legislative act, no? But what we can do is protect ourselves, no? So kung hindi pa naman po kailangan magpakasal, baka pwede pa po tayong maghantay kasi baka ma-lift na rin po yung MCQ natin soon enough, no? But those who cannot wait, no, for reasons that only they know, no? Ito po, inaalaw na po sa MCQ. Sa ECQ, bawal pa po. Sa MCQ, it is allowed already, but 5 persons max in attendance. Okay? So that's going to include the judge, and the judge's staff who has to take care of the documents, no? So 3 na lang po kayo, the bride, the groom, and another witness. Just to confess to all of you, I will have to do a wedding ceremony, preside over it next week, no? And so my chief of staff will have to be the second witness to that wedding, to that marriage, kasi 5 lang nga po ang pwedeng mag-participate, no? So the bride and the groom, their witness, plus my chief of staff who will assist me will be their second witness. So biglang naging ninong po siya ng wala sa oras, no? Are the collegiate courts operating? Yes, we are operating. I told you the CA is operating. The Sandigan Bayan, the Court of Tax Appeals, they're operating also. No, they have their own special rules also. So if you have litigation or cases with them, you have to inquire sa kanila yung special rules nila. But these administrative issued by the Chief Justice cover all courts, no? So what about the justices and the judges who are working from home? Well, what do? We continue to draft yung resolutions, tsaka decisions, no? Yun nga lang po, the promulgation is deferred until the courts become fully operational. Or pagka ng urgent matters, then we have to go to court so that we can release the action, the official action of the court in regard to the urgent matter. All right. Okay, and then finally, yung ating mga trial courts, meron na po tayong pilot courts na inallow ng Supreme Court to do hearings on all on all matters na po, in all cases, no? Civil, criminal, pare-pareho. They were given this platform, no? Yung Microsoft, I think 365 for video conferencing. And a lot of our trial courts are already using it, no? So all cases na po yan. Ngayon, paano po yung course na not equipped or not kasama dun sa pilot courts na yon? Sila po will continue to hear only urgent cases, no? Kasi wala po silang equipment or they are not pilot courts for the video conferencing, right? Okay. So let's go to the next slide. Well, that's just the general community quarantine. So I already discussed that. Okay, so let's go to section 6, which is the oral offer of exhibits. I've already mentioned this. So there's a cross-reference here to Rule 132 under the Rules on Evidence, and I've already discussed that with you. Oral offer, and then oral objection, and then the oral ruling of the court, no? So, ano nga yung rule natin on oral offer? Well, for testimony, you have to distinguish, no? For testimony, you have to offer it before the witness starts testifying, okay? For the documentary and other evidence, when do you operate? Of course, after you've completed the presentation of all your testimonial evidence, okay? All right. And then next, let's go to suspension of action, section 8. Right. So the same rule pa rin po, no? But remember, sinabi natin, no more motion for suspension of action if there is no TRO or writ of preliminary injunction from a higher court, right? Okay, now let's go to demurrer to evidence, Rule 33. Okay. So it says under section 2, that a demurrer shall be subject to the provisions of Rule 15. Yung rule natin on motions, okay? You remember still from last session, we discussed that now there are litigious motions and non-litigious motions, okay? And of course, a demurrer to evidence is a litigious motion, okay? So the order denying the demurrer to evidence shall not be subject of an appeal or a petition for certiorari, prohibition, or mandamus before judgment. Ang ibig pong sabihin, if the motion, no, to demur, or the demur to evidence is denied by the court, you cannot raise it on appeal kasi hindi pa tapos ang ating case, 'di ba? Na-deny ang demurrer mo, ibig sabihin proceed pa tayo with the presentation of the defendant's evidence. And then you cannot also question it via certiorari, no? Rule 65. Ito po kasi ang karaniwan nangyayari para sa akin kasi ito, this is parang an indirect form of forum shopping eh. Kasi you file a demurrer to evidence, no? So you bring squarely the issue of the sufficiency of the evidence that you have presented as plain, no? And then when the court rules on it and denies it, no, as that the evidence or the evidence presented was sufficient, ipapa-inhibit mo yung judge. Yan ang laging nangyayari. Or ipapailan mo siya ng certiorari, sasabihin mo grave abuse of discretion, no? Which I think is not right, no? Kasi we ask the court to rule on this matter, and then after the court ruled on it, all of a sudden we'll say that the judge should be inhibited kasi may bias na siya, no? Kasi winay na niya yung evidence mo, but you ask for it, okay? All right. Okay, so there at the bottom, I just have a quote from you, no? So it's the distinction between failure to state a cause of action and failure to prove a cause of action, no? Iyan yung essential distinction between a failure to state a cause of action and lack of cause of action. Yun. Kasi yung failure to state a cause of action is a defect in the pleading, all right? And it's a ground for dismissal, no? It's a ground for dismissal, formerly under Rule 16 as a motion on the motion to dismiss. Ngayon po, doon po sa ating affirmative defenses, no? Pero yung lack of cause of action, that goes into the sufficiency of the evidence presented by the plaintiff, okay? So a dismissal on ground of lack of cause of action is a dismissal under demurrer to evidence, under Rule 33. So you can only file it by way of an application with the court, a motion, no, after the plaintiff has completed his or her evidence presentation. And if the court grants it, then it is a dismissal on the merit. It's like a judgment on the merits, no? So yun po yung distinctions of failure to state a cause of action and lack of cause of action. All right, let's go to Rule 34, judgment on the pleadings, no? By the way, yung distinction between failure to state a cause of action and lack of cause of action, bar question ko po ulit yon in the just concluded bar examinations, no? And yun na nga, sadly, ang dami pa rin pong confused between those two concepts, no? And then now we go to judgment on the pleadings, okay? So under section 2, this is a new provision. The court may motu proprio or on motion render judgment on the pleadings, diba? Remember, I'll refresh your memories. Last session under pretrial. Now you can include in your pretrial order, our judges are listening. You can include in your pretrial order that the case is being submitted, no, for judgment on the pleadings or for summary judgment. Pwede na po ngayon after kayo mag-pre-trial, no? Of course, as long as the requisites or the conditions are present, no? So that is the court motu proprio, no? Submitting the case for judgment on the pleadings or summary judgment, or it can also be by motion, and it will be a litigious motion if it's by motion of the party. All right? Okay. And then the same rule, no appeal, okay? No appeal or no certiorari prohibition or mandamus, meaning Rule 65. If the court denies, no? If the court denies the motion of a party to render judgment on the pleadings, no? Then you have to wait, no? Kasi hindi tapos ang ating litigation, ang ating kaso. Kasi nga na-deny yung motion mo for judgment on the pleadings, meaning there will be evidence presentation, okay? So appeal is definitely out of the question. What about Rule 65, grave abuse of discretion? Pinagbawal na po namin kasi like I told you at the beginning of our session last week, no, sa CivPro, I told you that the majority of the revisions were to streamline. We wanted to exclude yung mga unnecessary interlocutory incidents, no. So we are removing this, no, from the table as available remedies. Anyway, you go through the trial, and once there is a judgment, you assign these errors on appeal. Para isa na lang. Kasi ang nangyayari, isa lang yung kaso, pero ang dami ng umakyat na interlocutory incidents sa CA, no? Sometimes there are 3 divisions in the CA handling 3 different Rule 65 petitions, no? Arising from one mother case, no? So magulo po talaga eh. Kaya we thought it best and we thought it wiser, no, to do this. Okay? So when is judgment on the pleadings proper, no? Bar question din po ito last nung 2019 bar exam namin sa REM, no? It is the judgment on the pleadings is proper, sabi sa atin ng rule, when an answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleading, no? So kailan nagfe-fail to tender an issue yung answer? Kung inadmit lahat ng allegations ng plaintiff, di ba? So, or kung hindi man inadmit lahat, yung hindi niya inadmit are irrelevant. Okay? They do not go into the core of the controversy between the parties, no? So pag ganun, wala na tayong kailangang evidence na i-present kasi nandun na, just by looking at the complaint and the answer, nakita na ng judge, inadmit mo na pala. Okay? Kumbaga, the cause of action pleaded in the complaint, all the elements have been admitted by the defending party, no? So that being the case, there is no necessity for presentation of further evidence. So kaya pwede na tayo mag-judgment just based on the pleadings, right? Okay, let's go to summary judgment. Rule 35, no? So when do we have summary judgment? If after an answer, a party plaintiff or someone who has a claim, no? Pwede rin counterclaimant ka, okay? Or cross-claimant. A party with a claim may move with supporting affidavits, depositions, or even admissions, no? For a summary judgment. And this is when there is no genuine issue of fact, no? Except as the amount of damage. Under the law, the moving party is entitled to judgment, no? So anong distinction, no? Pareho kasi, ang pareho sa judgment on the pleadings and summary judgment, no issue, no genuine issue na, no? Kasi yung sa judgment on the pleadings, no more genuine issue kasi inadmit, okay? So there's no genuine issue remaining between the parties, okay? Now, sa summary judgment, no genuine issue of fact na, okay? Kasi si moving party, the party who has a claim and who is asking for summary judgment has already presented affidavits, depositions, or admissions, judicial admissions, no, to establish the entitlement to summary judgment. Yun ang distinction nila. Okay? Sa judgment on the pleadings, walang prenisenta except the pleadings. You're making your judgment based on the pleadings, all right? Pero sa summary judgment, meron na. You're using affidavits, depositions, and other admissions. Okay, so that's the only distinction between the two. All right. Okay, so as I said, no, if it's by motion of a party, then it's a litigious motion, and you have to give notice to the other party. You have to serve a copy, no? I mean, you have to serve a copy, okay? There has to be proof of service, all right? And then automatic, there has to be an opposition. And only if the court deems that the hearing is necessary will there be notice of hearing originating from the court. Ang court po ang mag-i-issue niyan kasi ang court lang ang may power na mag-set for hearing. If the court, by looking at the motion for summary judgment, the opposition plus the affidavits and depositions and the admissions attached to the motion, no? And also to the comment if the party opposing if the party opposing also attached his or her own countervailing affidavits and depositions. Kung sa tingin ng judge, hindi na kailangan marinig ang mga parties, klaro na rin sa kanya from what he has in front of him, then there is no necessity for a hearing. No? Only if the judge feels that he needs to further look into the issues of facts, no? Facts ang pinag-uusapan natin ha, hindi law, na prinisenta ng mga parties, then that is the time that the judge can set it for a summary hearing. Okay? All right. And then the same rule, no, as in judgment on the pleadings, if it's denied, there can be no appeal from it and there can be no Rule 65, right? Okay, and then Section 4, under Section 4, we just added the phrase, no, including the extent to which the amount of damages or other relief is not in controversy and direct such further proceedings in the action as are just. Itong Section 4 kasi this has to do with judgment on the pleadings or summary judgment which do not cover the whole or the entirety of the case. Like, it's only an issue, ang na-cover ng judgment on the pleadings or summary judgment, and may natira pa. Okay? So kung may natira, ito yung provision doon. No? The judge now may order that further proceedings be had. No? Ano yung further proceedings? Aba, presentation of evidence na tayo. No? Okay. Or kung judgment on the pleadings yun, no? Pwede kang kung hindi ka pa naka pre-trial, pwede ka na mag-pre-trial and then trial. All right? Okay, and then on the succeeding slide, you just have some jurisprudence that will further explain the concept of summary judgment and judgment on the pleadings. Now, that's for your own reference at your leisure. And then now we go to Rule 144, which is the effectiveness. Ito po yung tawag nila dyan, effectiveness. I do not know if that is the correct word. Hindi po siguro dapat effectiveness. But anyway, ito po yung on what cases will we apply the revisions and from what dates. No? So it says here, under the underscored provisions, that they will apply, no, to all cases filed after May 1. Okay? So nag-umpisa na po tayo. We are now May 20 today, no? And also, ito po, dito po tayo magkakaroon ng questions, no? And also all pending proceedings, okay? Except to the extent that in the opinion of the court, their application would not be feasible, okay? Or would work injustice. In which case, the procedure under which the cases were filed shall govern. Okay? So binibigay po sa judge ang discretion, no? So ang dalawang condition lang, if not feasible or if it will work prejudice to the parties. Okay? So pagka ganon, hindi po daw i-apply sa pending proceedings. All right? And then the remainder, the second paragraph there, it's just about monitoring, no, which will be done by the Office of the Court Administrator, and again, submission of reports by our trial courts, no. And then the last part, it says that all rules, regulations, resolutions, or circulars of the Supreme Court, which are inconsistent with any of the provisions under the amendments, shall be deemed repealed or modified accordingly. So ito na po, no, ito na po yung ating repealing clause, no. So every other rule that is inconsistent with any of the revised provisions will be repealed. But if we can harmonize the interpretation, then under statutory construction rules, we should harmonize. Okay. So that officially ends the the discussion of the amendments to the revised rules on civil procedure. No, so now we will proceed to the questions. Before we go to the questions today, or asked today, we will discuss the ones that were sent to me ahead of time because they were the questions raised last session. No, okay, so I'll start with the questions here. The first question, this is a question from our host from the Divina Law Office. So the first is, does the prohibition on extension of pleadings other than an answer also apply to petitions for review and other appellate proceedings? No, so my answer will have to be no. Okay, kasi yung pong ating ni-revise na provisions are provisions on civil actions, both ordinary and special civil actions, okay? Whereas yung mga petitions po na tinatanong nyo, like let's say the petition for review under Rule 42, those are under appellate proceedings po, where they have specific timelines, no? And hindi po sila kasali doon sa ating ni-revise, all right? And plus, I think the more important answer is that when we defined pleadings, no, to which the amendments will apply, we defined them in Rule 6, Section 2. We referred only to the complaint, the answer, the reply, no, and the rejoinder if allowed. So hindi po kasama yung mga ating initiatory petitions on the appellate level. Okay? And then second, it's more a comment, no? Ang sabi po, I'll read it, no? In requiring the judicial affidavit in support of the complaint to be prepared well ahead of the answer under Rule 6, no? We will inevitably ask factual questions in the judicial affidavit which could possibly be admitted by the defendant in the answer, no? Marami pong comments na ganito, no? The other comments, hindi pa po daw nakakapag pre-trial, and during pre-trial parties could still make admissions and stipulations, or the parties could even settle, right? No, so sayang naman daw kung ginawa na yung judicial affidavit. Now we've heard all these comments before when we did the judicial affidavit rule, no? Ang sabi rin po nila noon, bakit natin isasubmit yung judicial affidavits before the pre-trial? What if they settle during pre-trial, no? And our standard answer is, we do not want to wait for trial to see the evidence that you have, no? More especially now, no, when we have given the judges the tool, no, to dismiss outright at pre-trial, no? On the basis of what has been submitted. No, that's why we have that judgment on the pleadings and the summary judgment also. So hindi po natin magagawa yung mga ano ba yan? I don't want to call them shortcuts, but I want to call them streamlining, okay? So why go to trial? Why force the presentation of evidence kung dito pa lang I can already render judgment, no? So yun po yung thinking namin dyan, no? So wala naman pong masasayang doon, no? Kung nagka-settle kayo, nakasave na rin kayo kasi nagsettle na kayo, no? So don't think about it. Don't think about it as sayang. Wala pong masasayang sa trabaho nyo. Lahat po yan gagawin natin kasi gusto natin mapabilis ang mga processes natin, no? Don't we always complain about justice delayed, justice denied, and now we're giving you the tools to streamline our trial process. So I hope you will cooperate with us, okay? And then the third question is it correct to say that a notice of hearing is no longer required to be included in written motions because of the revision to Rule 15? And then under Section 6, that hearings on litigious motions are discretionary. Correct on both points, no? So wala na pong notice of hearing. Di ba, ano pa yan, dati, that is really required under Rule 15, no? Pag wala kang notice of hearing, scrap of paper ang motion mo. Ngayon po, wala na. All that we are requiring is that you have proof of service, yung proper proof of service as we discussed last session, okay? Now, even litigious motions do not necessarily have to be heard by the court, okay? Ang litigious motions po natin, kung pwede na pong i-resolve ng judges natin just on the basis of the motion and the automatic or mandatory comment, hindi na po kailangan i-set for hearing, no? The judges are only allowed to set litigious motions for hearing if meron pang issue of fact na hindi klaro sa kanila, okay? So pag ganon, they can set a hearing on that motion, no? Pero ang judge na po, ang court po natin, ang mag-i-issue ng notice of hearings about it. You will just receive a notice from the court if the court deems it necessary to hold a hearing on your litigious motion. Otherwise, our rule is this, no? If you receive a motion, no, a litigious motion, you must immediately file your comment. Meron lang po kayong window of 5 days, okay, from your receipt to file your comment on the litigious motion. So, wag na po kayong maghintay ng court order, okay? Kasi yan po yung sinasabi namin, yung proseso natin. Bakit pa tayo nagre-require ng service sa adverse party kung i-issuehan din natin sila ng order to comment, no? So, bakit pa natin nire-require? Sasabihin natin, kasi ano yon, right nila, due process right. Okay, may due process right sila. May right, meron ding right ang court, no? For them as officers of the court, PD administration of justice. So alam mo na notify ka na, huwag ka na maghintay na sabihan kita mag-comment ka dyan. Kasi pag hindi ka nag-comment within the 5-day period, okay, deemed waived na yung comment mo, no? And the court can resolve and will resolve the motion already even if it's litigious, okay? Now we go to questions which were received by email, no? So the first question is, judges in some authorized areas are now asked to conduct trial via video conferencing. Yes, ito po yung sabi ko, yung pilots, no? How can the court consider a party or counsel duly notified of a hearing, particularly a pre-trial, such that their failure to join by the pre-trial set by the court via video conferencing may result in either dismissal of the complaint or the right of the plaintiff to present evidence ex parte? No, yung notices po natin, as far as I understand the guidelines issued in the administrative circulars we discussed on ECQ and MCQ and GCQ, will be sent electronically, no? Iyan na po yung ating preferred mode ngayon, no? Kasi wala naman po tayong mga postman na mag-iikot ngayon, no? Kahit po yung mga operations siguro ng mga couriers very limited. All right? So the preferred mode will be electronic, no? So but ang importante po ay ganito, no? For example, you have the PAO office, okay? And the fiscal's office in the same hall of justice or in the same complex of justice, no? So pwede pa naman ang personal service doon, no? Yung madala po ng personal sa kanila, yung notice of hearing natin, halimbawa sabihin natin sa bail hearing, no, sa PDL. So pwede pa naman po yung ganun, no, na kung feasible, kung hindi po mababiolate yung rules ng quarantine natin, pwede pa rin po naman yung ating mga traditional modes, no? But here, in answer to this question, I will repeat, the preferred mode now is electronic, okay? Sa ating pong mga administrative issue, right? So, ang importante doon, there is proof that there was electronic sending, no? And diniscuss po natin kung ano ang proof natin ng electronic transmission, hindi po ba? Okay, just to remind you, no, it's the proof of electronic transmission is the acknowledgement, no, or proof of sending, and then meron pong print out. We have to print out kung ano yung pinadala natin, no. So that's the proof of electronic notice, okay? And then the next question is, what companies are the accredited couriers mentioned under the rules, under the revision? To my knowledge, wala pa po, no? Kasi the OCA is supposed to come up with the rules, no, to accredit the private couriers, no? So before the OCA could get to that part, no, nagkaroon na po tayo ng pandemic, and so na-overtake po ng circumstances itong accreditation process. But I'm sure very, very soon the OCA will be able to come up with the guidelines, and you will be informed, no? And then number 3, in small claims cases, once the court sets the video conferencing and orders the parties to download the app so they can join the hearing, but they failed to connect, maybe due to their own fault, like deliberate failure to abide by the order, may the court now consider their failure to join the hearing via video conferencing a ground to either dismiss or decide in favor, as long as duly notified and there's proof of notice, and as long as they are at fault, no? So wala pong just because it's via video conferencing or electronic means, pareho pa rin ang rule natin, no? At the bottom, what we want is for every party to have his day in court and for every party's right to due process to be respected, no? So kung meron po yung dalawang yan, you can impose the sanctions that you normally impose under the circumstances, okay? Ito po, may question naman, may the family court refuse to avail of substituted service service of summons in a case for declaration of nullity of marriage, no? I'm not a family court judge. I was never a family court judge except when I acted, no, for my pairing court nung nag-retire po yung pairing court ko. I acted there, no? But there is a provision in the rules on declaration of nullity of marriage regarding service of summons on a defendant whose whereabouts are unknown, which is actually a copy of what we have in our rules on ordinary civil actions, no, na if the whereabouts of the defendant are unknown, then you can serve by publication, okay? Of course, that has to be coupled with service also at the last known address, no? Ngayon, ang word po na ginamit doon sa rule on declaration of nullity is may, no? So parang binibigay po natin sa judge natin ang discretion, no, to allow it, no, if the other party, the petitioner, wants to avail of it, if the judge thinks that it will be fair, no. But of course, ibang nature kasi ng nullity and nullity cases natin, di ba, tsaka annulment cases natin. Lagi we are guarding against collusion of the parties, no, kaya nga may required investigation and collusion pa yan. So in the judge's assessment, no, kung if it will just, parang be a disguise for collusion, the judge probably can issue an order disallowing it. Okay, all right. Next question. Are lawyers or agents allowed to represent on behalf of plaintiffs or defendants during pre-trial? Opo, no? That has always been a rule. You can be represented as long as your representative is duly authorized to do three things. What are these three things? No, first, to enter into a settlement. No, hindi po pwede na authorized siya pero pagka meron pwede po bang magpa-reset ako, judge, kasi I have to ask my principal. Hindi ho pwede yun. Then that person is not really authorized. Okay? Ang kailangan po natin, yung ating pong ipapadalang agent or author representative must be able to make a decision on an offer of settlement right there and then. Otherwise, delay na naman po ang lalabas pagka ganyan po ang ating representative, no? The second, your agent or representative must be authorized to participate in any mode of alternative dispute resolution that will include CAM or court annex mediation and JDR also, okay? And then third, your representative or agent must be able to enter into stipulations or admissions that will bind you. Okay, yun lang po tatlong bagay na yon. It must be evidenced by a written authority which is notarized, and you have or your representative should bring it to court. And then pwede na po siya mag-participate fully as if you were present yourself. Okay? And then the next question, is conflict of schedule of lawyers due to their scheduled hearings in other courts a justifiable ground to grant the motion for postponement? No. Okay? So no. An emphatic no. Okay? Ang lawyers po, marami na pong decisions ng Supreme Court. You should manage your calendars para maging po tayo, efficient tayo pare-pareho. Kung marami po kayong hearings, marami rin po kaming hearings, marami rin po kaming cases, but we manage to keep our cases, no, and schedule them or calendar them in an orderly fashion para wala po tayong mga ganyang problema. And under the revisions sa rules natin on civil procedure, only 3 grounds are allowed for postponement, no? And we've already mentioned them today: acts of God, force majeure, and then the third one is physical inability to go to court. And sabi ko nga po, under that will fall yung mga medical reasons natin or medical conditions. Definitely, conflict in schedule is not an acceptable ground for postponement, okay? Okay, may a complaint that has stated a cause of action, okay, through ultimate facts, but then failed to back this up by sufficient allegations on evidentiary facts, okay, be dismissed for failure to state a cause of action. I like this question, okay? Pwede po siyang pang-bar question. Okay, kasi ngayon, if you go back to the provision on what a complaint should state, it still uses the phrase ultimate facts. Pero dinagdag po, including the evidence. 'Di ba? Hindi sinabi including evidentiary facts, sinabi including the evidence, 'di ba? And then it refers to yung mga judicial affidavits, etc. Okay? So, pwede mong i-argue, no? Kasi tayo naman I was also a practitioner for 10 years before I joined I joined the bench. Madali natin to i-argue. Sabihin natin yung language ng yung language ng provision is ultimate facts pa rin, and then the evidence it does not refer to evidentiary facts. So kung ultimate facts pero naka-attach ang evidence ko, nandiyan lahat na judicial affidavits ko, na mark lahat ng documentary evidence ko, I don't think that you can dismiss it for failure to state a cause of action, no? Kasi that to me is going to be too technical, no? Nadi-defeat yung objective natin pag ganun. Pero kung halimbawa, ultimate facts lang tapos wala pang evidence, walang naka-attach, no? Iyon po, pwede po nating i-dismiss, no? Let me just remind all of you that when we or right now hindi na tayo pwede mag-motion to dismiss based on failure to state a cause of action, na sa affirmative defense na lang natin yan pwede invoke, okay? If you invoke failure to state a cause of action, the judge is limited to the four corners of the pleading. Okay? Yun po yun. Kasi we are hypothetically admitting, okay, the stated facts in the complaint. Okay? So having hypothetically admitted them, can I now, being the judge, render judgment based on these allegations having been admitted? Kasi kung hindi, then yun. Failure to state a cause of action po yun. Yun po yung ground natin na failure to state a cause of action. Okay? Okay, next. Considering that the notice of hearing isn't required anymore for litigious motions, will this now cure unresolved motions which lack the notice of hearing but were filed prior to the effectivity of the new rules, no? If curative, should the party which received the motion which lacks the notice of hearing under the old rules just file its comment? Oh, ito po magkakaano nga tayo dito. Medyo gray area po ito, no? So what do judges do and what do litigants do also dun sa mga actions nila na pending na, tas inabutan po ng effectivity nitong new rules natin? Let's say, as in this particular case, no, meron ng motion, pero that motion lacked a notice of hearing. So under the old rule, before it was revised, that's a scrap of paper, di ba? So pag scrap of paper, it does not deserve the court's attention. If we are going to be technical about it, before the rules were revised or before the revisions took effect, wala na siya, trash siya, scrap of paper siya, if I'm going to be technical about it. No? But if we want to really resolve the issues on the basis of the parties, on the basis of the merits, no, and not on technicalities, what the judge can do in this particular case is to issue an order, diba? And declare that, no, that we are applying the revision of the rules, we are directing the other party to file a comment, no? Bakit kailangan mag-issue ng order? Dapat di na mag-issue ng order kasi automatic na yon. Yes, automatic po yun. Kung kayo inabutan nung effectivity ng rules natin noong May 1, dun pa lang kayo nag-file. Lahat to automatic. No question about it. Hindi kita bibigyan ng directive. Kaso, dito sa mga cases na pending, hindi maintindihan ng parties. I-apply kaya ni judge or hindi kaya i-apply ni judge? Mag-file kaya ako ng motion kay judge. Judge, can we apply the revised rules? Or judge, please do not apply because it's not feasible. It will prejudice my clients' rights. So in those instances where the proceedings are already pending, no, and where there may be prejudice to either one or both parties, now kayo po mga counsel, you have to take the initiative. No, wag niyo na hitayin si judge mag-determine for you. Sabihin niyo na agad ba't kayo mape-prejudice, so the judge can act on it and can declare, okay, we will continue to apply the old provisions, no? So yun po yung medyo magiging konting gray area natin dito. Okay? So please remember this. Huwag tayo masyado maging precipitate, no? Kasi baka in this particular instance, isipin ng judge, hindi na siya dapat issuehan ng order to file a comment. O lapse na yung period niya to comment, 5 days lang yun. I will resolve it already. Hindi na po siya nadinig, no? And all the while, the party was thinking, apply kaya ni judge yung revision or will we still use the old rules, no? Okay. All right. And then the next one is, if a party received okay. So now we'll go, sorry, I'm repeating. So now we go to questions received via Facebook, no? So the first one is receipt of an actionable document, I may be wrong, wasn't there an SC case that a receipt is not an actionable, is a receipt an actionable document? Okay, I may be wrong. Wasn't there an SC case that a receipt is not an actionable document? I think the one who sent the question is referring to the case of Duarte, no? This is a 2011 case penned by Justice Mardel Castillo. Okay, doon po sa case na yon, sum of money, no, meron silang, may laptop, no, the object was a laptop na pinagbili, okay, sabi, oh, bibilin mo ba tong laptop ko? So ibinigay niya, ibinigay nung seller yung laptop niya, tapos nagbayad 3 times, okay, nagbayad 3 times yung buyer, may na balance na I can't remember anymore how much, no? Pero nung sinisingil na niya yon, ayaw na siya bayaran. Kasi sabi, hindi, yung laptop mo naman kasi is just worth so much na yun na yung amount na nabayad ko sa'yo. Okay, so because the buyer didn't want to pay the balance, ang ginawa po ng, nag-file ng case for sum of money, okay? And the claim for sum of money was based on the contract of sale, okay? So please remember that. Kasi what is an actionable document? An actionable document is a writing or a document or an instrument on which you base your claim or defense. In this particular case of Duarte, the claim for sum of money was based on that contract of sale, okay? But in the course of the hearing, to prove lang na ang nabayaran lang nung buyer was so much, okay, as opposed to their agreed purchase price, itong seller, nag-present siya ng acknowledgement receipt, okay? A handwritten acknowledgement receipt of X amount which was paid by the buyer, okay? So, ang ruling ng Supreme Court doon was, tama, no? There was a contract of sale. Kasi dito po, the contract of sale was not reduced into writing, okay? Kasi ano lang yun laptop. I think the amount was not even more than 50,000. Mura lang talaga, okay? So, hindi po na nila yan ginawa ng document or instrument. It was an oral contract of sale, no? So sabi ng court, hindi porke walang written contract wala ng contract of sale, kasi pwede yang oral, okay? Kasi when does a contract arise? Upon the meeting of the minds of the parties, right? So at that point, wala pang kasulatan, talagang pinag-usapan, may contract na tayo, okay? So sabi ng court, all right, may contract of sale, may utang ka talaga, okay? Now the court said that receipt is not an actionable document kasi hindi naman doon nakabase yung claim for sum of money, di ba? Ebidensya lang niya yon to prove na in fact, meron kang installment payment, pero yung payment mo is less than what you owe me. Okay? So, kaya po sinabi ng court dun sa Duarte, through Justice Del Castillo, that a receipt in that particular case is not an actionable document. No? Kaya nga po, I always tell my students, huwag kayo magbasa ng digest. No? To all the students listening to us today, no? Do not be happy reading a digest. Kasi a digest usually just gives you a sketch of the facts, no? But more often than not, di ba, ang digest mo mahaba, kino-quote yung discussion nung court, no? Yung ruling na, no? So hindi mo kasi maiintindihan ang concepts. Hindi mo maiintindihan yung tinatawag natin na precedent kung hindi mo alam to what facts they were applied by the court. Okay? Kaya ito po, itong particular question na to, it's the same thing, no? An actionable document will depend, no? Whether a document is an actionable document will depend, no? On whether a claim or defense is being based on it. Okay? All right. Now, next, our common practice was to have a verification with certificate of non-forum shopping only as one notarized document, no? Can we still do this? Well, certainly, pwede pa rin, no? Wala naman nabago doon, no? Dinagdagan lang natin yung verification, dinagdagan lang natin ng mga statements na kailangang i-include, and also, we said na yung signature doon ng party is also a certification as to truthfulness, veracity, etc. No? And then as to the certificate on non-forum shopping, pareho po with the verification, we just added na kailangan na authority nun signatory, no? Pero pwede pa rin po silang magkasama, okay? And then next question, regarding Rule 6, Section 3, no? Can the lawyer ask instead the client to sign the complaint because it's the client's story in the complaint? No, no, no. Yung complaint, yung pleading dapat pirmado ng abogado, okay? Kasi ikaw ang representative, ikaw ang legal representative ng kliyente mo. Kaya nga tayo nagkaroon ng bagong provision on the signature, di ba? Kasi we want the lawyers to put their uh, to put their money where their signatures are, so to speak, in a manner of speaking. Gusto po namin na yung pirma nyo will be given the faith and credit that it deserves, no? And it will only be like that if we will always be associated with that stamp of veracity and trustworthiness. Kaya nga po, in-include na natin tong provision on signature. Okay? So it has to be the lawyer that signs the complaint. Okay? And then next question, does the provision under the judicial affidavit rule contradict Section 6, Rule 7 with respect to the submission of the judicial affidavits? Because under the judicial affidavit rule, the judicial affidavits will be submitted before 3 days before pre-trial. O, ito na nga po yung sinasabi ko sa inyo kanina, no? Ito po yung mga medyo may konting medyo may konting reklamo sila why we moved up the submission of the judicial affidavits, no? Remember, under Rule 133, yung last po natin diniscuss on effectiveness, no? Any inconsistency, no? These new revisions will prevail. Okay? So ito na po ang magpre-prevail. Ito na po ang susundin natin sa lahat ng civil actions, ordinary and special civil actions. Right. Next, if the witness is a hostile witness, do we need to attach the judicial affidavit also? Isasabay ko na rin po itong isa, no? How can we attach the judicial affidavit, for example, of an assessor or the register of deeds or the police? Ito pong mga witnesses na to, magkakagrupo po sila, no? Yung judicial affidavit rule po, the day before it became a rule, no? I remember Justice Robert Abad, its author, called me, no, and said, Monette, can you read the draft rule, no, and can you give comments? Okay, so yun po, doon po, isa po kasi to dun sa mga nasabi po natin. Marami pong judges ang nakasama ko, na kami po ang nagsabi kay Justice Abad, nasabi namin, Justice, mahihirapan po ang trial courts na kumuha ng judicial affidavits for like the police witnesses, the forensic chemist, tapos ano pa po ba, yung ating mga medical legal, and the RD, true, no, the Register of Deeds, or those people coming from the LCR. Mahirap po lahat yan, yung mga galing sa gobyerno, no? And then, on the other hand, you have the hostile and adverse witnesses also. Kasi kahit isang pina mo sila, di ba, for the taking of judicial affidavit, which is allowed under Section 5 of the judicial affidavit rule, what do you expect them to say, di ba, when you're asking them the questions? Kasi nga hostile sila. All right? Okay. So dahil doon, ang naging agreement na namin, lumabas na po kasi yung JAR, no? So ang naging agreement na lang when we would lecture on JAR to the judges or to lawyers, sinasabi naman po na lang po namin sa kanila, reasonable po ang interpretation ng JAR when it comes to government officials or employees, no? And also, it is only logical also to exclude yung mga hostile at adverse witnesses from the judicial affidavit rule, no? Ngayon, nung nagkaroon na po tayo ng rules on continuous trial sa criminal cases, naging express na po iyan. Pero sa ating pong revised rule on summary procedure, talaga pong talagang iyan po ang sinusunod nating rule. Hindi po sila kasama dyan, okay? Ina-exempt po natin sila dyan sa judicial affidavits, right? Okay. And then, regarding Section 6 on judicial affidavits, would meritorious cases include failure to interview the listed witness who is in Manila and there is a COVID lockdown both in Manila and a no-sale policy in the other region or province where the witness is? Well, definitely, no, meritorious reason po iyon, no? So you can avail of the provision which allows one late submission, that's under the judicial affidavit rule. Now, are we circumventing yung rule po natin ngayon? No, hindi po, kasi nakalagay po dun sa present rule natin sa revision under meritorious or for meritorious reasons, no? So that could be a meritorious reason. But of course, you have to prove all of that, all right? And then next question is, um, Section 5, if the other party objects to the amendment, ito po yung amendment to conform to evidence. I think, no, kasi very ano po, very putol yung kanyang, very vague yung kanyang question. If the other party objects to the amendment, do we need to file a motion to amend with attached amendment, no? I guess ang kanyang tinutukoy ay yung amendment natin to conform to evidence, no? Kasi yung amendment to conform to evidence, it requires the consent of both parties or their lack of objection. So pagka walang objection, nagprepresent ng evidence on a matter which is not in the pleadings, we deem that to be an implied assent or consent, no? So either express or implied. So kung wala pong consent at nag-o-object nga, edi talaga pong kailangan po ng amendment yan, no? And that will be a litigious motion, all right? Okay. Next, is there a particular form required to secure the consent of the adverse party for purposes of serving pleadings through email and fax? No, wala po. Ang ating po mga trial courts will just innovate, no. Pero kami po, we prepared court forms, no, in civil cases, and I'm not sure if they are uploaded already on the website of the Supreme Court. Pero ang ginawa po namin, dun pa lang po sa umpisa, dun po sa complaint, basta initiatory pleading, complaint or answer, ginawan po namin under dun sa signature ng lawyer where you give your name and then your address, we already mandatorily require you to give your email address and your facsimile number if you have a fax. Yun na po yung ginagawa namin. So I think that is a practice which is very easy to adopt, and also walang additional expense or abala to all the parties concerned, no. So you can already start doing that even if the court does not require you. I-indicate nyo na po sa pleadings nyo, sa initiatory pleadings nyo, yung inyong email addresses and facsimile numbers, all right? And of course, by doing that, you are just manifesting that you are willing to be served electronically or via facsimile. Okay? And then the next one.
Okay, medyo naghang lang ng konti yung connection ni Jessie. So we'll wait for her. So we're seeing all your questions at the moment. Madami din na pumapasok ulit na questions additional. Some of the questions here na we're looking at the Q&A box, yung iba po nasagot na ni Justice Singh a while ago. But for the others na hindi pa, we'll ask her to answer them, no, when she comes back on. And then we're also monitoring the questions we're getting sa FB page ng UST Faculty of Civil Law. And also shout out also to the IBP QC chapter because they're also streaming this lecture via their FB page. So hello po sa
I'm
inyong lahat.
sorry.
Okay, Justice, welcome
I'm
back.
sorry.
Okay po.
Before we started, I told Attorney Renz and Dean Nilo that it's raining hard in my place, no? Kaya sabi ko, at some point I might get dropped, but I will just reconnect as soon as possible. So I'm back.
Yes,
I was talking about judicial courtesy. Walang courtesy itong ating internet connection. So anyway, so yun lang. Just to be clear, no, you need to have a TRO or a writ of preliminary injunction in order to successfully secure a suspension from the courts under the revised rules, no. And then next is, does the amendment in the rules, more particularly on the need to attach judicial affidavits and indicate the evidence, applicable to Rule 70 proceedings, no? Rule 70 po is ejectment, no? So with more reason, kasi summary procedure po yan, no? Sa summary procedure na civil cases, hindi po tayo nagtatrial, di ba? So talagang kailangan nyo yung mga affidavits ng witnesses nyo. And the rule, since the JAR was adopted by the Supreme Court, is that lahat ng affidavits, judicial affidavits, okay? All right, next is the pretrial notice, which is issued by the branch clerk, includes not only the schedule for CAM, but also JDR. But the necessity of submitting the case for JDR after a failed CAM is determined only after the CAM. Okay? So how would the BCC know if the case will be set for JDR? When the need for it is determined only by the judge and after a failed CAM. Okay? Ganito po ang reasoning namin dyan, no? Kami po ang nag-insist that we include this, no? Before kasi this is what will happen, no? So we will issue a notice of free trial, all right? But then the people will appear. Pero anong gagawin namin doon? I-refer lang namin sila sa CAM. Okay? So they are in court, the parties, the counsel, they are in court before us, kompleto sila, pero wala kaming gagawin except to refer them to CAM. Okay? So aalis sila, pupunta sila sa CAM. Okay? And then we wait for the report of the mediator, no? And then we get a report. Let's say it's failed mediation, and then we set it again, this time for JDR naman. Okay? So another notice from us, no? And another waiting period for the parties to receive the notice. All right? So lahat po ng oras natin nauubos doon sa ganon. And in the meantime, dahil nagpunta pa kayo sa CAM, nag-intay pa kami ng mga report ng mediator, nag-issue pa kami ng notices, napuno po na napuno yung kalendaryo ko. Kaya dapat kayo na sana, pero hindi ko kayo maset agad, no? Kaya kailangan na kayo maghintay kasi may other cases na nanauna sa inyo sa calendar ng court. And that is why we don't want that to happen anymore. And so we insisted that in the notice of pretrial, we already reserve the settings, no? For the CAM, for the JDR, and of course the pretrial. Ngayon, kung halimbawa ay nagsettle na po sa CAM or nagsettle na sa pre-trial, hindi na po natuloy sa CAM at JDR, wala nang po problema. Nalibre po yung calendar natin, tapos po yung kaso natin. No harm to any of us. Okay? You can just easily cancel that. And then ganun din po, if you proceeded to CAM but then JDR is no longer necessary, sabi ng court, okay, we can remove that other setting. In fact, we can use that date reserved for JDR as a date for initial presentation of evidence already. Let's say that hindi nag-succeed yung CAM and the judge thinks wala na talagang settlement. Okay, let's use the JDR date. Let's use it for trial. Pwede naman po yun. So sa tingin namin, mas malaki po yung magiging benefit by doing this rather than by going by the old way that we did it. Okay? Right. Next. Can we not just proceed to hear the case or incident considering the presumptive service on the non-appearing party? Why do we still have to issue a show cause order? I think that course of action by the court will not serve the purpose of expeditiously disposing of the case incident. Okay? Sasabihin ko po sa inyo ang dahilan, no? Actually, wala naman po sinabi that you cannot. You can. Wala po kami sinabi sa rule natin. In fact, under the rule on presumptive notice, very bare, no? Sinabi lang natin if the notice of setting of a court setting is served on a party who is within the same judicial region, 20 days lang po, may presumptive receipt na siya, no? And then if it's outside the judicial region, 30 days lang po. So kung wala po siya, may presumptive receipt tayo, you can certainly proceed. Yung sa akin po, yung suggestion ko last time that you issue a show cause order also is, ano po tayo, kung iniisip natin na mapapabilis tayo, like for example, di dumating, sige, waive na yung presentation ng evidence niya or proceed na tayo sa evidence ex parte ng plaintiff, no? Makakamabilis ka nga ngayon at this point, pero later on, I promise you, babalik yan sa'yo. Mag-MR po yan, kung hindi man yan mag-MR, magse-certiorari po yan, no? Or sa appeal, lalabas po yan, no? So, ganun din po ang kakauwian natin, no? Magkakaroon din po ng ganyang incident dahil doon sa ginawa natin. Whereas kung bigyan natin siya ng chance to explain, tapos hindi po niya napaliwanag, he was unable to give a valid cause for his absence, no? Despite presumptive receipt. Wala na pong question, wala na po siyang pwedeng gawin para pa i-delay yung proceedings natin. Tuloy-tuloy na po tayo, no? And that is also a badge of fair play kasi, no? We really do not know why the person was absent. Kasi presumptive notice lang po ito. Di bali po sana kung talagang meron tayong actual return na nakalagay doon, nakapirma siya, tinanggap niya, tas di siya dumating. No? But even in those instances, pwede pa rin siya magpaliwanag, no? Na aksidente siya, he was on his way to court, and then he met an accident. No? So iyon po, itong mga bagay na to, we know as judges, as litigants, these things happen on a fairly common basis. No? So ang ating laging rule of thumb, yung accord everybody their day in court. So hindi po tayo hindi po natin pwede i-sacrifice yon yung due process rights nila just for the sake of speed, no, na gusto nating ma-achieve. Okay? And as I explained, in the long run, mas maraming delay pa pong mangyayari sa atin pag ginawa natin yan. Okay? Now, should the substituted service on the officer of the homeowners or condo association be on the officer's address at the village or the condo? Or can it be served wherever the officer may be found? No? Ang tingin ko po sa rule natin, dapat po doon sa village or condo. Kasi yun po yung guarantee na makakarating yon, di ba? Kasi kaya natin inauthorize doon sa security officer sa condo kasi alam natin nandun siya. So definitely, mabibigay niya yan doon sa intended recipient, no? Kasi substituted service po ito eh. Now, doon sa village, ganun din po. Kung ang hahanapin mo yung officer ng homeowners association, hahanapin mo pa ba siya sa kanyang pinagtatrabahuhan, nandun ka na sa village, hindi po ba? So, iyon po ang intention ng rule na yon, okay? Now, what will happen to the motion to dismiss based on improper service of summons if the counsel on record will be deputized to serve summons to his or her client? Ito po yung incident na there is improper service of summons on a defendant and the counsel for that defendant appears in court, no, to question the jurisdiction of the court over his client, no? Ang nakalagay na po sa ating rule ngayon, pag ganun, pwede pong i-deputize ng court yung counsel to serve the summons on his client. And I explained to you the reason why we revised the rule and included that, no? Kasi ano po ba ang purpose ng summons, no? So, of course, alam po natin na kailangan nating mag-acquire ng jurisdiction, di ba? Over the subject matter and over the person. Kasi otherwise, hindi po maging binding sa kanila yung ating decision. Alright? Ngayon, ito pong defendant na to, nag-appear na sa atin through counsel, no? But only to question the jurisdiction. Pero nandun na. Nandun na po yung counsel sa harap natin. Kaya ang sinasabi natin, anyway, nandyan ka na para mapabilis na tayo. Let's resolve this case on the basis of the merits rather than on technicality. Okay? Kaya sinasabi po natin ngayon, nandyan ka na sa harap ko, serve this on your client. Iyan din po is a measure of the good faith, no, of the counsel and his client. Right? Yung hindi po sila nag-e-evade ng court processes. Right? Next question. Will the prohibition on extension of time also apply to CA and SE? Yun na po yung first question natin kanina, no? Sabi ko sa inyo, these rules apply to pleadings as defined under Rule 6, no? So complaint, third-party complaint, permissive counterclaim, cross-claim, tapos po answer and reply, all right? And then next, motion for postponement is limited to acts of God, force majeure, or physical inability of the witness to appear and testify. What if it is the lawyer who cannot appear due to sickness, example, or conflict of schedule? Okay, so when the resetting is made without his or her participation. All right, let's answer this, no? So, dun sa Rule 18 po natin sa pre-trial, niliwanag na po natin doon, di ba? Inad natin party and counsel, no? In fact, that is a revision. We added the participation expressly of the counsel, no? Sa pre-trial, yung presence niya. So, this will apply to a counsel, no? So, kung halimbawa, hindi po makakapunta ang counsel during pre-trial, by reason of act of God, or kung na-confine po siya sa hospital, okay, may certificate of confinement siya, okay po yun, no? That is an acceptable ground for a motion for postponement. Now, the other ground, tinanong po kanina, no? Yung tinatawag nating conflict of schedule, and I was emphatic that that is not acceptable under any of the three grounds natin, no? Pero ang nakalagay po dito sa question is, conflict of schedule when the resetting is done without his or her participation. Okay? 'Di ba? Minsan po nangyayari, nag-resetting tayo, hindi present yung isang party. So tayo na nag-agree, no? The present party and the court will agree on a date, no? And then the court will just issue a notice to the absent party. So nakalagay na po doon yung date of resetting natin, no? So pag ganun po daw, hindi kasi siya nag-agree, sabi niya, it should be considered a just ground for a resetting. Pwede po kasi ninyong ayusin yan before the date of pre-trial or trial arrives. As soon as you receive your notice from the court and you see that you have a conflict, you have to do the necessary already, no? So kailangan nyo na po na ipagbigay alam sa court, no? Na teka po, judge, nag-set po kayo, hindi po nakonsulta ang aking kalendaryo. It just so happened, no, na nung araw po na yon hindi po ako pwede talaga kasi meron po akong prior setting. So, is conflict of schedule now allowable, no? I'm sorry but I've always been like this, no? In my trial courts, I always exercised a reasonable interpretation of the rules, no? So, let me see. Ganun ba katagal ka nagkaroon ng pagkakataon para i-challenge to before the actual date? Tapos kailan mo lang ito nire-raise sa akin, no? Baka naman hindi kailangan na ma-postpone pa yung pre-trial natin kung during the lead time that you had notice of the conflict in schedule and the time of the actual setting, pwede na nating gawa ng paraan. So those things will go into consideration as far as I'm concerned, if I were the judge, no, in assessing if I will say that your motion is valid. Okay? All right. And then there's another question here. How can we enjoin an act through application for TRO together with a complaint if we need to attach the judicial affidavit of all the witnesses, okay? Like in an ejectment case, when the defendant is about to close the right of way. Okay, so ang comment pa is hindi pa tapos ang judicial affidavits, close na ang right of way. Okay, so I understand what you're saying, yung urgency, no? Can I just say, to be very, very frank about it, no? Lahat po tayo dito with the revisions with the revisions under the rules and civil procedure, we all have to do extra work, no? Pero ito nga sabi ko sa judges natin na nakausap ko kasi meron din pong nagsasabi sa akin, Judge, ang hirap, ang trabaho. Sabi ko, ina-advance lang natin ang trabaho natin lahat, no? Whereas before, itong trabaho na to will follow, di ba? Pagka magde-decide na tayo or after pre-trial, ngayon, advance na lahat kasi ginawa na natin lahat and then easy-easy na lang tayo sa trial, yung judgment kitang-kita na kasi andyan na nakalatag na sa'yo. Now, for the litigants, ganun din, no? Please do not go to court. Yun naman ang rule natin sa Code of Professional Responsibility natin, yung ating canon on diligence, di ba? Yung ating pong obligation sa ating mga kliyente, kung hindi po tayo ready, wag muna tayo pumunta sa court, di ba? Pag pupunta tayo sa court, yung talagang ready na tayo, kompleto na lahat ng ebidensya natin. And that includes your judicial affidavits because that's your testimonial evidence. So, pag kami mga urgent matter na ganyan, no, medyo magpupuyat po tayo siguro. Hindi tayo matutulog ng isang gabi, no? Ganun po talaga. That's part of our job. Ganyan po, alam po natin yan when we entered this profession. So, that's the end of the questions that were sent to me ahead of time from last session. So maybe now, Attorney Renz, we can answer the other questions.
Madami pa po tayong pumasok na questions,
Yeah.
Justice.
Okay, sige, let's
let's start with the first one. So we received the complaint against our client before the ECQ. So this is before the ECQ. Okay. We will be filing our answer after the lifting of the ECQ. Can we opt not to attach our judicial affidavit to the answer, given that the judicial affidavits of the plaintiffs, witnesses were not yet attached to the complaint?
Okay, my answer there is it's not your option, okay, because this is a rule that has been adopted and passed by the Supreme Court. So it's mandatory on all of us. But the rule on effectiveness gives the discretion to the judge, okay? So the judge, if it is not feasible or if it will work prejudice to one or both parties, can opt not to apply the rules, di ba? Yun ang nakalagay doon. So what your remedy is to go to the judge and tell the judge, Judge, this will work prejudice to us kasi magiging unfair yung treatment kasi yung plaintiff hindi naka-attach ng judicial affidavits pero kami naka-attach ng judicial affidavits. Okay? So, but what the judge can do in that case, kasi this is fairly early in the litigation, no? Nasa answer stage pa lang kayo, the judge can now ask the plaintiff also to submit their judicial affidavits and other evidence para bago kayo pasagutin. No? So para lahat will be done already in accordance with the new rules. Okay? I think that's the better option in your case. Thank you.
Okay, Justice, another question. Are these rules applicable to intra-corporate disputes?
Hindi po, meron pong specific, may specific rules po ang ating intra-corp disputes. Very, very particular po yung kanilang rules.
Okay, Justice, I think maraming questions talaga dun sa postponement tsaka yung conflict of schedule. Most of the questions are coming from solo practitioners. I think medyo legit na concern siguro nila to. They're saying that after the lifting of the MECQ and then transition to GCQ, sabay-sabay dadating yung mga notices of hearing set by the court.
Okay.
So, ang question nila, if that happens and then talagang magkaroon ng conflict of schedule, so paano yung gagawin nila given that hindi allowed yung postponement?
Okay, all right. I think you can call that act of God kasi pandemic po yung reason natin sa lahat na yan, 'di ba? All these things are happening to us because of COVID-19, no? So I think that is one of the exceptions natin doon sa motion for postponement natin. Hindi naman kayong nag-reset niyan, na-reset yan dahil sa lockdown, no? So that is certainly beyond all our control. So I think that's a valid reason.
Madami pumasok na ganung question, Justice.
I understand.
Okay. How will these amendments affect the special civil actions like petition for certiorari, etc.?
Yun nga po kasi if you look at the definition of what a civil action is, 'di ba? Merong two types 'yan, yung ordinary civil actions natin tsaka yung special civil actions. And the rules on civil actions are applicable to both. Okay? So, pero lagi po ninyong tandaan, no? Pagka meron po tayong specific rule on a particular type of action, okay? Like yung sa special civil actions, no? Meron silang particular timelines, meron silang particular procedure, no? Lagi po magpre-prevail yung specific sa general. Remember, these are general rules kasi, okay? So, kaya yung specific, lagi pa rin po nating bibigyan yon ng preference or priority. Kasi these are just general rules that apply pagka wala pong specific rule in place.
Okay, another question po. Given the removal of Rule 16, does filing of a motion to dismiss on grounds allowed by the rules interrupt the period to file an answer?
Okay, very limited na po ang grounds natin sa motion to dismiss, 'di ba? Yung apat na lang. Yes, it will still interrupt, no? Kasi ano 'yan that is understood because that takes the place of your response for now because you are questioning the court's jurisdiction, or this is already barred by prior judgment, or this action is already prescribed, or there is another case pending between the same parties for the same cause. Now, these are causes that will prevent the court from exercising its jurisdiction validly. Kaya kailangan i-resolve agad, no? Kaya yes, it will toll the filing of your period to answer.
Okay. How about cases governed by special rules like nullity of marriage? Will the new rules apply?
Iyan po, just to reiterate, no, yung mga cases po natin where the Supreme Court has approved or passed special rules, no, hindi po natin sila kino-cover. Yung mga special rules pa rin po mag-a-apply, no, unless those special rules are silent on certain points, in which case, in a suppletory manner, we will apply these general rules.
Okay. Is MR allowed when demurrer to evidence is denied?
Hindi po, bawal po. Nakalagay na po 'yon, no? Like in the judgment on the pleadings and summary judgment, bawal ang MR, bawal ang ating what do you call this, appeal, no? Bawal ang appeal, bawal ang Rule 65.
Okay, I'm from the province of Guimaras, so we are under GCQ. No trial pa rin daw ba sila except for urgent matters lang muna. I'm
They're under
about
GCQ.
They're under GCQ. I'm about to
Okay.
issue orders na kasi setting all the hearings that were canceled.
Okay, Judge, if you are not a pilot, no, nung ating ano ba 'yon, yung Microsoft 365, I think, yung may video conferencing, then that means magfe-face to face kayo. I understand ha, no, my understanding, but you also please read the administrative circular of the Chief Justice. My understanding is that all urgent matters, no? Yun po ang understanding ko sa ECQ and sa MECQ. Okay, yun po understand. Pero GCQ, kung GCQ po kayo, I think you are open, no, for all incidents. That's my understanding. But please double check. I may be wrong.
Okay. Okay. In the period of time to present testimonial evidence, could there be an exception when it comes to class suits where there may be multiple plaintiffs and defendants?
Yes, definitely. Yes.
Okay. Okay. Regarding the motions, is it correct that only litigious motions need to be served to the adverse party? Does it not require due process that all motions should be served to the adverse party, though if the motion is non-litigious, no hearing on the motion is necessary?
Okay. So kasi po ang definition natin ng non-litigious motions are those which the court may act upon without prejudicing the rights of the adverse party, no? So kahit alam mo yan, 'di ba? At kahit hindi mo yan alam, pwede nang aktuhan yan ng court. Hindi ka natatawagin talaga eh. So practically speaking, hindi kailangan ng notice kasi pwede nang ang aksyonan ng court kahit hindi po na notify yung isang party. Pero sa akin kasi, para lang in the interest of fairness, no? At saka for notice also, ibigyan mo na lang siya ng copy, serve mo siya ng copy, but it's not required, okay? It's not required for non-litigious motions.
Okay. I think this question might be coming from a judge. Are judges required to issue a specific order to state that the new rules will not apply to a specific case?
That is my suggestion, Judge. Kasi for those cases na pending na po nung naging effective yung rules natin, kasi I'm sure magkakagulo po yung parties ninyo dun sa cases na yon. They will wonder, will the new rules now apply to us? Tapos yung first question nga natin, Attorney Renz, di ba? Yung party plaintiff nag-file ng complaint, walang judicial affidavits, now they have to file an answer, tapos mag-judicial affidavit sila. So I think it is the better practice, no, for our judges ngayon for your pending cases na naabutan po nitong revisions natin to issue an order for the parties' enlightenment and guidance also. And in that way also, the judge will determine na, is it feasible in this case? Is it advisable? Or will one party or both parties be prejudiced? So parang nagme-make na rin ng determination yung judge natin kung dapat mga bang i-apply ang revisions. Okay?
Okay, Justice, there's a question. There is a notice of explanation still required in pleadings, motions, and other submissions. I'm thinking ito yung notice of explanation why substituted service will be used instead of
correct. Yung pong mga provisions natin na hindi ginalaw, nandyan pa po sila. Kung nandyan pa po sila at hindi po sila dinelete, no, then you still have to comply with them. Yun po yung point natin doon, no? So yun naman po kasi is just a guarantee that you resorted to the hierarchy, that you followed the hierarchy, na inuna mo yung personal service, sinunod mo yung registered mail, no? Or before you did substituted service. Pero alam nyo po, with the introduction of electronic service, parang nawala na po yung hierarchy na yon kasi baka ngayon mas preferred na rin natin yung electronic service, 'di ba? So kaya hindi na po siguro ganun kahalaga ngayon yon with the introduction of electronic service.
Another question, will the new rules apply to summary proceedings like ejectment cases?
Like I said, no, may special rule po tayo sa summary procedure natin, yung ating pong revised rule on summary procedure. Iba po ang timelines natin doon. Iba rin po ang mga pleadings na pwede nating i-file doon. Required po doon, verified lahat ng pleadings natin. So those special rules will prevail over the general rules.
Okay. Ito po yung seeking clarification lang daw on presumptive notice.
Okay.
So in case the presumptive notice sets in, is the plaintiff still required to move to declare the defendant in default, or the defendant is automatically in default?
Kasi po yung presumptive notice is presumptive notice of a court setting. So, wala na pong default doon kasi ang ating pong default proper lang is when you do not file an answer. Okay? Baka po ang sinasabi niya is non-appearance at pre-trial. Wala na po tayong as in default. As I mentioned last time, what will happen though is that the plaintiff's presentation of evidence ex parte will be set. No? Yun po ang mangyayari. So, wala po tayong default na mangyayari sa presumptive notice. Again, to repeat the presumptive notice that you find in the new rules or in the revised rules refers to presumptive notice of court settings.
Okay. Justice, merong isa nag-ask clarification daw. What kind of flow chart is being referred to in Rule 18, Section 7G?
Okay.
The famous flow chart.
Yung mga, if you have tried a case under the continuous trial for criminal cases, you will be familiar with the flow chart. Kasi that is required doon po sa ating pong mga criminal cases na kino-continuous trial. Basically, it's just a schedule of trial also. Sinasabi kung ano yung incident, sa criminal cases, arraignment, pre-trial, and then initial trial for the prosecution, etc. Ganun din po sa atin sa civil cases, no? Of course, it will start with the pre-trial, no? And then we go to court annex mediation, JDR, and then trial for plaintiff. Ganun po yun. Basically, that's the flow chart.
Justice, clarification daw on Rule 14, Section 3. So when the court authorizes the plaintiff to serve summons together with the sheriff, can the lawyer perform this on behalf of the plaintiff? Or should it be the plaintiff himself or herself?
No, kasi it refers to the plaintiff or the plaintiff's representative eh. Hindi naman tayo unreasonable na i-require natin yung plaintiff in every instance. And plus, we have many plaintiffs which are juridical entities. So it must necessarily be done through a representative. Now, if the lawyer wants to be the one to do it to do the service with the sheriff, pwede rin po. Basta kayo yung authorized na pinangalanan ng plaintiff in court.
Okay, siguro underbar nagtatanong nito. Asking for a general advice to those who will be taking the bar. How do we approach the amendments to the rules, Justice?
Approach it with an open mind and with a courageous heart. No, but seriously, I'm very excited about the revisions sa civil procedure, no? Kasi ito yung mga ginagawa na naming judges matagal na eh, no? These are the practices that we have come up with in the past to deal with the volume of cases, no? Yung talagang hirap po nung problema namin. Ito po yung mga naging solution namin doon. Kaya tuwang-tuwa po ako na now na institutionalized na po siya, no? And that all will be using them already, no? So doon po sa ating mga law students, those about to take the bar, no? You are lucky. Kasi when you pass the bar, I say when, not if, ha? So dapat mag-aral kayo mabuti. When you pass the bar, ito na po ang rules na gagamitin nyo. Hindi na po kayo dadaan dun sa napakahabang proseso natin before.
I know for a fact, Justice, that you've been one of the people who've been working on the court automation project. Tagal na, no? Even back to the QC days pa when we were piloting yung automated hearings and then even yung e-subpoena. Kasi may mga questions din pumasok about yung video conferencing that's being used now. Can we expect that this is the new normal for the judiciary, like yung taking advantage of available technology? Kasi naalala ko nung when we visited Washington DC, parang nangangarap lang tayo yung video conferencing. But now pala, kahit with limited infrastructure, kaya naman natin palang i-pull off.
That is so true, no? Kaya nga sabi ko nga, Attorney Renz, no? Parang itong pandemic na to, it forced our hand to actually do what we needed to do like 5-10 years ago, di ba? Yung pong ating project on automation, ang tagal na po kasi noon medyo hindi po masyadong fully maka-take off, no? Kasi alam niyo naman po ang challenges ng Supreme Court, ng judiciary when it comes to resources, no? And but despite that, hindi naman po tayo nagpapahuli, no? So nandiyan po yung essentials. But with this pandemic, no, talagang nakalat po sa buong Pilipinas yung video conferencing, no? Everybody was forced to get acquainted with it, no? And not only that, to actually use it, no? Which is very, very good kasi ito na po talaga dapat ang ating normal, no? This will save everyone a lot of expense, not just for when the pandemic is still around, no? Kahit na po mawala na po to, magka-vaccine na tayo, dapat isipin natin na ito ang efficient way to do things, no? Kasi less cost to everybody, wala namang wala namang pong loss or sacrifice of the rights of the parties, no? Especially in civil cases.
As a follow-up question to that, Justice, no, yung, for instance, yung mga hearing on the motions, and this could be particularly useful for lawyers who are from out of town, no? Kasi yung across judicial regions,
yes,
baka pwedeng yung hearing on the motions could be by video conferencing, just
yes,
like what's
exactly.
being done in other areas in the world.
Oo. Kasi even yung ngayon, very useful sa criminal cases natin because alam nyo po, kami naghihiring pa kami sa Muntinlupa. Kasi for example, if our accused is already serving sentence for another offense and is in the maximum security prison there sa Muntinlupa, hindi po siya pwede ilabas under our rules, no? So kami ang pumupunta doon. Imagine going from Quezon City to Muntinlupa, no? Dala-dala mo yung buong staff mo, yung stenographer mo, everybody. Tapos to brave that traffic along C5, going to and coming back, no? So with video conferencing, lahat po parang nasosolve para lahat po ng problema natin. Makakatulong pa rin tayo sa traffic problem natin. Mababawasan po yung lalabas ng mga sasakyan sa ating mga lansangan.
So we could definitely expect this as the new normal now for the judiciary and also for the legal profession. So
yes, I'm praying for it. Yes. Nakakatuwa nga kasi a lot of our senior members of the bench talagang they are studiously updating themselves kung paano gamitin tong mga platforms na to. So I'm very happy actually about this development. Parang silver lining siya.
Parang blessing in disguise.
Right.
Mga pangarap lang natin. No?
Oo nga.
Okay, I wish we have more time, but there are more questions, Justice. So ang gagawin na lang po natin for the other questions that have not been answered by Justice Singh, we will just forward everything to her.
Yes, please.
And we'll try to respond to everyone via email for your other questions na hindi nasagot, no?
Yes.
And then, of course, if you want to have a copy of the PowerPoint presentation of Justice Singh, both for evidence and actually civil procedure, they can be downloaded through the FB page of the UST Faculty of Civil Law. Nandun po lahat, even yung video nitong ating session, all 3 sessions actually will be there for everyone to view. So with that, we would like to thank Justice Singh for your time and grabe yung exhaustive and comprehensive itong iyong presentation. So to give a closing message, may I call on, of course, the Dean of the UST Faculty of Civil Law, Attorney Nilo T. Divina.
Thank you, Renz. Justice Monet, on behalf of the UST Faculty of Civil Law and the various IBP chapters that carried this broadcast, all stakeholders of the law profession, law students, reviewees, practitioners, judges, thank you so much for unselfishly finding time to share your expertise, your competence and your knowledge to us about the new rules of civil procedure and evidence. The fact that we had to organize a 3rd session clearly indicates that this webinar has been a smashing hit or success. And on my own, I have to say that I had to do last-minute corrections on the book that I wrote about the revised corporation code, particularly about the power to sue or be sued by the board of directors, because there are various Supreme Court decisions that you can dispense with the board resolution if the following persons will be the ones
to appear,
sign the plea.
Yes.
Stand for shopping, like the president, chairman, general manager, PM, human resource specialist. You had to revise it to say that to append you're pleading the authority, the proof of authority, better err on the side of caution, no? Rather than be corrected by the Supreme
Yes.
Court and face the consequence. I also learned I'm a corporate lawyer, but I was tuned in all throughout the discussion because of the refreshing approach and clear discussion, Judge Bennett. And I'm so happy and so proud that you are officially part now of the Faculty of Civil Law. Thank you so much.
Di nag yellow gold ako just to
I know, I noticed
just to
that. Thank you. Thank you.
signify that I am proud to be now a member of the Faculty of Civil Law of the UST. My
Oh,
mom's
thank you
alma
so much.
mater.
Thank you so much. Thank you.
Marami po
Thank you so
salamat
much.
din for this
Thank you.
opportunity. Attorney Renz, maraming salamat. To the UST Faculty of Civil Law, thank you. And to the Divina Law Foundation, thank you. To the IBP of Quezon City, my home chapter, marami pong salamat. And to all of you who patiently listened through all the 3 sessions, marami pong salamat kasi by updating yourselves on the new rules, that means you are diligent lawyers, you are diligent students, you are diligent practitioners and upholders of our rule of law. Marami pong salamat sa inyong lahat.
Thank you very much, Justice Singh. And that concludes the 3 parts of our the lecture on the revised rules on civil procedure and evidence. We would also like to ask you to watch out for our upcoming webinars. We will be having one on e-commerce law. This is going to be part of our transition to the new normal, so rights of the consumers in relation to online buying. So this is, I mean, given the increase in the online purchases since the lockdown, even prior to the lockdown, and then more so during the lockdown. So we will have a resource speaker coming from the DTI. So please visit our Facebook page, the DL Facebook page, for our announcements on the final schedule of that webinar. So with that, we thank everyone who joined us this afternoon. Of course, thank you very much, Justice Monet Singh, and of course, Dean Milo T. Divina. And of course, everyone who joined us here in Zoom and also via the Facebook pages of the UST Faculty of Civil Law and the IBP Quezon City Chapter. Magandang tanghali po sa inyong lahat and keep safe everybody.